Welcome to this explainer. Today we're diving into the absolutely fascinating, foundational principles of South African contract law to figure out what actually binds us together. I mean, think about it. Contracts are basically the invisible threads holding our modern society intact, from that cup of coffee you bought this morning all the way to the lease on your apartment. But what really makes a contract, a contract? Today we're going to break down the anatomy of a contract by looking at the exact legal principles from our source material.
Okay, let's jump right into this, with a scenario pretty much all of us have experienced. Before we get totally bogged down in dense legal jargon, let's just ask a really simple question about an everyday social setup. Let's say you agree to meet a friend at a restaurant at, say, noon. You've made an arrangement, right? But if your friend just completely flakes and cancels at the last minute, can you sue them for a breach of contract? It was an agreement, for sure. But is it a contract?
Well, spoiler alert, the law draws a very clear line in the sand here. While a coffee date is definitely an agreement, it only creates a moral duty. You might be super annoyed, but a judge isn't going to help you get your wasted afternoon back. A true contract is a whole different ballgame. It's concluded with the serious, absolute intention to create legally enforceable obligations. The whole difference lies in what the parties actually intended and the heavy legal consequences attached to that agreement. So, long story short, not all agreements are contracts.
So, here's our roadmap for this explainer. We're going to cover 1. Agreements versus real contracts. 2. Requirements for valid contracts. 3. The freedom to contract. 4. Constitutional and equality limits. And 5. Contracting in the digital age.
Let's start with Section 1, Agreements versus Real Contracts, the Intention and Consequences.
So the real kicker here is the creation of what the legal world calls an obligation. An obligation is basically the legal relationship that locks the parties together. When this relationship is born, the parties instantly acquire personal rights against each other. That means they are officially entitled to demand performance, or they are legally obliged to perform, based entirely on what they agreed to. Now, this performance could be actively doing something, like painting a house, or it could even be agreeing not to do something. A contract is essentially the spark that creates these legally binding obligations. Oh, and here's a fun fact. It takes at least 2 parties to form this legal relationship. You literally cannot contract with yourself. The only weird exception our source mentions is if you happen to be acting in a completely different legal capacity on each side of the deal. But generally speaking, it fundamentally requires a meeting of 2 or more distinct people to create that binding link.
Moving right along to Section 2, Requirements for Valid Contracts, the 5 Pillars.
As outlined right in Chapter 3 of our source material on the law of contract, the law does not mess around here. It prescribes extremely strict requirements that absolutely must be met for an agreement to have any legal bite. If you miss even just one of these, you might have an agreement, sure, but you definitely do not have a valid contract in the eyes of the law.
The absolute bedrock, pillar number 1, is consensus. You'll often hear lawyers call this a meeting of the minds, which is actually a really great way to picture it. It means every single party to the contract must have a serious intention to create rights and duties that they will be legally bound by. But simply having the intention inside your head isn't enough. They need a corresponding intention, meaning everybody is completely on the same page. And crucially, they have to actually communicate this intention to each other. You can't just secretly agree to something in your own head. Once you have that solid consensus, here are the other 4 pillars you need. Step 2. Both parties must have the legal capacity to act, meaning the law actually recognizes them as capable of entering a contract. Step 3. The agreement has to be legally possible, as in lawful. Step 4. It actually has to be physically possible to perform the duties. You can't contract someone to fly to Jupiter tomorrow. And finally, Step 5. If there are any prescribed formalities, like maybe the law says the specific deal has to be in writing, those must be strictly followed. A valid contract only exists when all 5 of these steps are locked in.
Which brings us to Section 3, the freedom to contract, choosing who and what. Here's the general rule. You have the freedom to choose exactly who you want to do business with, and you get to dictate the terms of that agreement. It's a huge principle that protects your personal autonomy in the economic world. But there is one massive caveat to this freedom. You can do all of this provided the agreement is not unlawful. You absolutely cannot use your freedom of contract as a free pass to conclude illegal agreements.
And that brings us to Section 4, Constitutional and Equality Limits, when freedom is restricted.
See, the South African Constitution is the supreme law of the land, and it doesn't just protect freedom, it fiercely protects equality.
To enforce this, we have the Promotion of Equality and Prevention of Unfair Discrimination Act of 2000. This act gives equality courts some seriously wide-ranging powers. As the act itself states, courts can literally step in and make orders to provide opportunities that were unfairly denied. This is a game changer for contract law because it means the legal system will intervene to stop unfair discrimination based on things like race, gender, or disability.
Let's look at how this plays out in the real world. Think about these two scenarios. Say a landlord named Vanja refuses to rent a property to Edgar, and her only reason is his race. Or, imagine a local golf club flat out refusing Avira's membership application simply because she's a woman. In these exact cases, the equality courts can actually force Vanja and the golf club to conclude those agreements. So your absolute freedom to choose who you contract with hits a brick wall the very second it crosses into unfair discrimination.
Finally, let's wrap up with Section 5, Contracting in the Digital Age, the Paperless, Faceless World.
As Section 3.4 of our source material highlights, the internet has become wildly commercialized since the 90s. We're buying retail items, managing our banking, and even securing insurance entirely online. All of this lightning-fast transacting happens in this unique digital space, which forced the legal world to ask a pretty tough question. Do the old traditional rules of contract law still hold up when we're dealing with invisible electronic transactions?
To clear that up and create some legal certainty, South Africa relies on the Electronic Communications and Transactions Act, better known as the ECT Act of 2002. And the core rule it established is huge. An agreement is totally binding even if it was put together just using data messages. A data message is basically any data generated, sent, received, or stored electronically. So a contract isn't invalid just because it's a quick email back and forth or a click on a website instead of a physical piece of paper signed with a pen.
Now, before you go signing everything away via text, there's a catch. While the ECT Act applies to pretty much all commercial and non-commercial data messages, there are some very rigid exclusions built right into the law. You absolutely cannot use a simple data message to draft a valid will, and you can't use it for the alienation of land, which is a fancy way of saying buying or selling real estate. Those big-ticket items still require the old-school formalities, but for almost everything else, your electronic data messages carry a massive amount of legal weight.
So, as we wrap up this explainer, I really want you to think about everything we've just uncovered. Knowing that a simple electronic data message can carry the full heavy weight of those 5 strict pillars of contract law: consensus, capacity, legality, possibility, and formalities. Ask yourself, how many legally binding messages have you sent today? Every single time you click I agree or confirm an online order, you are actively engaging with the deep, foundational anatomy of contract law. Thanks so much for joining me on this explainer, and I will catch you next time as we continue to decode the complex systems running our world.